Judicial Watch is still doing the heavy lifting on the Clinton email scandal. I told you about the document we just uncovered. Now, Hillary Clinton is in the middle of her email scandal, if truth be told. Now, I know the Justice Department doesn't want to do anything. I know the State Department doesn't want to do anything. I know Congress doesn't want to do much of anything. But you know what? There are some courts who are interested in doing something. And it's because of Judicial Watch's litigation that's causing these courts to be interested. Next month, we'll be in court before Judge Sullivan over questions that we submitted to Hillary Clinton under oath, written questions that she didn't want to answer. We're seeking to compel her to answer. So her lawyers will be there. And we also have a specific request to bring her in under oath, to have her testify in person before Judge Royce Lamberth. And this is in the Benghazi scandal lawsuit that we have that was thwarted by the FOIA games, or the Clinton email games, the State Department and Hillary Clinton engaged in. The hearing took place last week, and I told you Judge Lamberth was unhappy, but I didn't have the transcript, so I was going by memory, so it's never nearly as dramatic as reading it from the transcript, but I had the transcript here. And the transcript was pretty incredible. So, to bring you back to the moment, I'm there with our lawyer, Ramona Kotka. There are two Justice Department attorneys on the other side, a relatively empty courtroom. There may have been a reporter or two and some of our colleagues there. And the judge comes out and he starts talking. And Judge Lamberth, who's been on the court for some time and has seen a lot of government corruption, including cases that Judicial Watch has pursued with him, he says almost immediately, I gotta put my glasses on so I can see far enough away. Put on my disguise here. The case started with a motion for summary judgment here, which I've denied, and allowed limited discovery. Now, summary judgment is generally the government will file a motion for summary judgment saying, look, we gave Judicial Watch everything, nothing else to look at, nothing else to give them, everything withheld is proper. You should summarily issue a judgment, or you should grant our summary judgment motion and end the case. So Judge Lamberth says, no, I didn't buy into that. He said, which I denied and allowed limited discovery because it was clear to me at the time that I ruled initially, and this was 2 years ago, that false statements were made to me by career State Department officials, and it became more clear through discovery that the information that I was provided was clearly false regarding the adequacy of the search in this, what we now turned out to be the Secretary's email system, Hillary Clinton's. I don't know the details of what kind of IG inquiry there was into why these career officials at the State Department would have filed false affidavits with me. I don't know the details of why the Justice Department lawyers did not know false affidavits were being filed with me, and I was very relieved that I did not accept them, and I allowed limited discovery into what had happened. So he was happy he was not gamed and didn't end the case. And then later he writes, I was waiting most for the IG report from the Justice Department Inspector General. That's the IG report I referenced earlier. I did print out and read that 500-page report when I got it, and I was actually dumbfounded when I found out in reading that report that Cheryl Mills, Hillary Clinton's top aide at the State Department, had been given immunity because I had in an earlier case called Alexander versus FBI that Judicial Watch had pursued. I had myself found that Cheryl Mills had committed perjury and lied under oath in a published opinion I had issued in a Judicial Watch case where I found her unworthy of belief, and I was quite shocked to find she had been given immunity by the Justice Department in the Hillary Clinton email case. So I did not know that until I read the IG report and learned that, and she had accompanied the secretary to her interview. So he was dumbfounded. And then we had the Justice Department spend the next 20 to 30 minutes trying to argue with the judge why the Justice Department, State Department didn't lie to him. You don't need to be a lawyer to know you don't want to be in that position before a federal court judge. The State Department told me it produced all records when it moved for summary judgment when you filed that motion. That was not true when the motion was filed. At the time, we had produced all, the lawyer says in response. It was not true. Yes, it was. Well, Your Honor, it might have been that our search could not be inadequate, but the declaration was absolutely true. It was not true. It was a lie. It was not a lie, Your Honor. Well, that's doublespeak. There's a strong precedent saying that items not in the State Department's possession did not need to be searched. And that's because the Secretary was doing this on a private server, so it wasn't in the state's possession. So you're playing the same word game she played? That was what's in the court transcript that I just read you. Pretty incredible material, isn't it? You know, when he granted our limited discovery back in 2016, this is what he wrote. When there is evidence of government wrongdoing and bad faith, as here, wrongdoing and bad faith, we at least had a federal court judge say something more substantial than James Comey and Loretta Lynch. Limited discovery is appropriate. Judicial Watch is certainly entitled to dispute the State Department's position. It has no obligation to produce these documents because it did not possess or control them at the time the FOIA request was made. This is what the State Department was saying under Obama, and it's saying now. That because Hillary Clinton, with the State Department's implicit approval, had taken 60,000 emails away, destroyed half of them, they didn't have to look for them because they weren't in their custody or control. Boy, that's one way to destroy FOIA, isn't it? The State Department's willingness to now search documents voluntarily turned over to the department by Secretary Clinton and other officials hardly transformed such a search into an adequate or reasonable one. Judicial Watch is not relying on speculation or surmise, he uses the quotes the government uses, as the State Department claims. Judicial Watch is relying on constantly shifting admissions by the government and the former government officials. Constantly shifting admissions by the State Department and Hillary Clinton. That's how that translates to. So you can read the entire transcript on our Judicial Watch internet site at judicialwatch.org. But I encourage you to do so. Now, Judge Lamberth did not rule on our discovery motion at the hearing. He's going to go back and see if the government has any case to be made, presumably, to stop discovery from going forward. But you've got to understand, the State Department, under Secretary Pompeo, and I don't blame Pompeo directly for this, he may not know about it, but he ought to know about it, is protecting Hillary Clinton. They don't want additional questions asked of Hillary Clinton, and they don't want additional questions asked of Cheryl Mills, who Judge Lamberth excoriated here, and they don't want additional questions asked of the State Department. So they're protecting Hillary Clinton, and the institution of the State Department is protecting itself, the deep staters, from having to answer for their enabling and complicity and conspiracy with Hillary Clinton to avoid FOIA and destroy government records. She had no right to take those emails. She had no right to destroy them. They contain classified information, numerous potential criminal acts by Hillary Clinton. And the Justice Department is happily representing the State Department's legal position here. So Judge Sessions needs to be held accountable here too, and the leadership of the Justice Department.